Dear students, Namaskar. Today I am going to discuss the new chapter which relates to services under the union and the states. Means that the services of the government employee which are related to the union laws and related to the state laws are to be discussed in this chapter. In case if we talk about the general survey about the conditions of services under the union government and the state government, we can say that the permanent civil services was regarded as the steel framework of the British Empire in India. Even after independence, the framework continues, though some time, though some attempts are periodically made to reorient it with the new objective of republic. In our constitutions also contains elaborate provisions in regard to the services under Article 309, 310, 311 and 312 of the Constitution. And all these provisions contains the basic rights and protection available to the members of various services or persons holding civil posts under the union or the state government. It also defines the power that the states may exercise. Usually such matters are left to be regulated by ordinary legislation and do not find a place in the constitution. However, we can say the law relating to the government services in India is separate over in many places. Means that it is found in constitutions, it is found the acts enacted by parliament, it is found in the states act enacted by state legislatures, and also found rule and regulations made by the appropriate government, directions, clarifications issued by the authorities, and moreover, uh, it is also found in judicial decisions and or judicial pronouncements made by the courts time to time according to the condition and situation arises uh, related to the conditions of services related to the union government and the state government. These have to be combined with the principles of natural justice. Means that although all those directions, rules, regulations, laws, acts are supposed to be applied, but all those are to be applied in the light of one important doctrine, that is the doctrine of uh, natural justice. Means that all those cannot be applied, all those cannot be observed in the absence of principle of natural justice. And moreover, the provision of fundamental rights contained under Article 14, 15, and 16 of the Constitution. The courts have a delicate task to perform. They must give an they must give an amount of security to the employer, to the employee, yet ensure that he performs his duties with all care and honesty. The government, as employer, must have the necessary power to discipline the employees who neglect their duties or are corrupt or indulged in the corrupt practices. But the power has to be exercised, you know, very judicious manner and very carefully, not arbitrarily. So, first of all, it's Article 309. 309 provides that the Parliament or the state legislature may regulate the recruitment and conditions of services of the persons appointed to the public services and post in connection with the affairs of the union or the state government, as the case may be. The legislation will be subject to the provision of constitutions. Means that there could not be the violation of the provision of constitution, especially as I would mention earlier also that is the provision of fundamental rights. So the article contains a proviso. Article contains a proviso means 309 contains a proviso which authorizes the president or person authorized by him or the governor or any person authorized by the governor to make the rules until the parliament or the state legislatures undertake a legislation. So, if any act is passed, the rules made shall be subject to the act. It has been held that the rules making power conferred by proviso to 309 is legislative power. It is extension of legislative power. Uh, the- so the rules framed are statutory rules and have the forces of law. So they are binding on the employee as well as on the government. Under this power, of rule may be made to take effect retrospectively. Sometimes that in case if the situation demands, then the rules may be framed by the government retrospectively also. So the power under the proviso was intended to be in the nature of an interim power to be exercised by the executive till the legislative take over. Now, question arises कि why left to the executive? But in fact, as all of you know, that legislature has left the field to the executive for the purpose of making rules, regulation, etc. So the uh, union and the state makes a recruitment to a large number of posts. So the essential and the desirable qualifications and length of experience required vary from post to post. So required from post to post, and so that's why the uh, modes of recruitment by open selection, by deputation, by promotion, or limited departmental examination, etc., is the best left to the executive because it may be conveniently change the mode in the light of experience gained. Under Article 320 of the Public Service Commission, it's the UPSC, Union Public Service Commission, and State Service Commission, as the case may be, has to be consulted on all matters relating to the methods of recruitment and the principles to be followed in making the appointments. So the government find it convenient to consult the commission while making a rules, but if it is a legislation, the procedure may be cumbersome and time consuming. So that's why they, there are few acts governing the recruitment to services, and those acts only lay down a skeletal framework, leaving the rest to the done by the delegated legislation. As all of you know, why we also discussed that why there was a uh, need of the delegated legislation, because of the reason that it's only the acts or the parent act which lays down the lays down the selectal or selectal framework of the law or of the act. But the gaps has to be filled up by the executive. The gaps has to be filled up by the administrative authorities, because they know the practical experience, they know the difficulties which could be arisen and which could not be arisen. So for the purpose of overcoming all those difficulties, it has been empowered, it has been the left and conferred to the executive to make the rule and regulation related to the conditions of services of the union government and the state government. Now, it is not obligatory for the government to frame the rules for creating a service or post, for prescribing qualifications, experience, and pay scales, etc. So, Article 309 does not limit the right of state under Article 73 or Article 162. It can be recruit persons in exercise of its executive power. So, if an act or rule exists, the government is bound to follow it. If the rules is silent on a particular point, then the government may issue appropriate directions to fill up the gap or to clarify any kind of doubts or any kind of ambiguity, or may supplement the rules. But the instructions issued must not be inconsistent with the rules and law. Means that although the government has been empowered to pass the instructions also, but all those must be consistent with the laid down rules and enacted law. So, and instruction cannot amend or alter the rule, because as all of you know, as a rule cannot uh, amend the parent act, and on the same basis, on the same reason, the instruction also cannot amend the rules, because instructions are supposed to be issued in the light of the prescribed rules, and rules are to be enacted in the light of, or in the light of parent law. So as we have so many discussed about what the function of the executive, that the function of executive to enforce the law, to implement the law, to execute the law by enacting laws, bylaws, rules, regulations, notifications, etc. So you know that including in case of this situation, including instructions time to time. So, but there are the relation between the law and the rules, and rules and the instructions. So that's why the central government or instructions cannot amend the law or alter the rule. So the in central government, the financial rules, the pension rules, and the reservation rules have numerous instructions, because the instruction has to be passed, or have to be passed time to time by the government, and added to them by the Ministry of Finance and Department of Personnel. Then the law, rules and fundamental rights, means that the law making rules, the law making and rules making power conferred under the proviso of 309 is likely other act or rule subject to the fundamental rights. The rules must be just, fair, and reasonable, and this applies to the instructions also. Means that the instructions passed by the government, all those are to be pass the test of justness, fairness, and reasonableness. So not only the rules, but the practice of government must not be arbitrary, because you know that both your arbitrariness or justness or fairness are the sworn enemies to each other, as we have discussed in our previous lectures under Article 14 of the Constitution. So here I'm going to cite one examples of unfairness which has been decided by the Supreme Court in one case. It was the Ratanlal versus State of Haryana, where the state government followed the practice of employing teachers on ad hoc basis for one session only so that they were not entitled to the wage for the summer vacations and other benefits. So it was held that the practice is unjust, unfair, and unreasonable. So the government must function as a model employer. Means that the government could not exercise its power arbitrarily or unfairly. So the special rules, that here are the special rules also, uh, which should be that it should be uh, noted that for the recruitment of subordinates judiciary, for the uh, recruitment of the officers of Supreme Court, for persons in audit and accounts department, the power to frame recruitment rules is given in other articles of the Constitution. For example, we can say that it is under Article 146, 148, 234, etc. Then Article 310 is another important article, which which talks about the and which can be termed as that it's the ancestry from the English law, as I have got mentioned that the services rules has been uh, termed as steel framework of the British Empire in India. So it's also happens with the Article 310, and it derives its ancestry from the English law, where the rule is that all services, all services means military or civil, under the crown is held at the pleasure of crown. So the services of a public servant may be dispensed with and may be dismissed at the will of the crown or at the will of the president or the will of the governor, as the case may be in India. So there is no need to assign reasons. Means that the person or the government servants will be holding the post during the pleasure of the president or during the pleasure of the governor. So our constitution recognizes the doctrine of pleasure, but makes it subject to another important uh, provision that falls under Article 311. That so that the civil servants, uh, here we are talking about the civil servants only, not about the armed forces, because the civil servants have some constitutional safeguards, constitutional remedies. If a civil servant is removed or dismissed or reduced in rank, the formalities and procedure prescribed under Article 311 must be followed. Means that the power under 310 is subject to the provision of Article 311. And there are exceptions to this rule also, that the Constitution contains special provision which assigns a fixed tenure to the office holder. There is a fixed tenure. Under this tenure, the office or post is held during the good behavior and not under the doctrine of pleasure. Means that it is the exception to the Article 310, not under the doctrine of pleasure. For example, at the judge of the high courts, judge of the Supreme Courts, the Auditor General of India, the Chief Election Commission of India, the chairman and the members of Public Service Commission, like the chairman and the members of the UPSC, and the chairman and the members of your state public service commission. That all those are to be kept under the heading of exception to Article 310. But they can be removed. They can be removed on the proved misconduct or proved misbehavior, and all these posts are to be termed as constitutional posts. Now, another now as we are talking about Article 310 and 311. So now, in case if we talk about the Article 310, that the doctrine of pleasure is embodied under Article 310 of the Constitution. So the effect of Constitution provision is that first, that it cannot be fettered or limited by a contract. Second, it cannot be fettered or limited by the rules made under 309 or by an act of parliament or the state legislature. Article 309 is subject to 310, but Article 311 is a fetter on the doctrine of pleasure. Means that Article 311 is a restraint or is a check on the power of doctrine of pleasure. So it is meant that it is meant to be constitutional safeguard. The As I could mention, that the fundamental rights under Article 14, 15, 16 control the manner in which the pleasure is to be exercised. So it cannot be exercised, again we can say, discriminatory, unfairly, or arbitrarily. So the law does not require that pleasure under Article 310 be exercised by the President or the Governor personally. Means that in case if we talk about that as and when if the person holds the office or removed from the office, is that the personal power of the President or the Governor? That all, as we have discussed so many times, that in case of the parliamentary form of government, either it's the President or the Governor, they will have to exercise their power with the aid and advice of the Council of Ministers, and by the authority specified in Acts. Means that which authority has been specified in Acts or rules made under Article 309, and it is not necessary for the President or Governor to consider the matter personally. Now, what are the constitutional safeguards to a civil servants? As we have discussed, that it's the article, because although Article 310 is there, which talks about that the civil servants will hold his post during the pleasure of President or the Governor, as the case may be, but that is subject to the provision of Article 311, which talks about the constitutional safeguards to the civil servants. Now, the constitutional safeguards or certain safeguards and protection to the civil servants or the government servant, it is to be noted that they are available only to first of all a member of civil service of union or the state government, a member of all India services like your IAS, IPS, etc. A person who holds a civil post under the union or the state, they are not available. The member, that all these safeguards are not available to the armed forces or armed personnel, because they are not subject to their services are not subject to Article 311 of the Constitution. Now, Article 311 provides two safeguards or two important safeguards. First, it's Article 311 Clause 1 states that a person entitled to a protection of Article 311 shall not be dismissed or removed or by a authority subordinate to the rank that by which he was appointed. Means that their services cannot be dispensed with less than the rank of the officer, less than the rank of the employer who has appointed him, because those employer or those rank of employer had been appointed him, he could be dismissed or removed or reduced with the rank of the person who had appointed him or employed him. Then next, the no such person shall be dismissed or removed or reduced in rank except after inquiry. Means that there has to be an inquiry, holding of inquiry, and in that inquiry he must be informed. The delinquent employee, we can say the person who has been charged, served a charge sheet, he must be informed the charges or charge sheet against him. Then third most important, that he must have been given a reasonable opportunity of being heard. And for your kind information, that prior to the 42nd amendment, the opportunity of being heard was to be given at the two stages. First, in respect of the charges against him. Second, when when it was proposed to impose a penalty. Means that as there were two stages when the opportunity was being given to the employee. As and when the charges are going to be framed, then he was supposed to give a charge sheet, and before after giving charge sheet, as and when there is going to be imposed a penalty by the disciplinary authority. So, but after 42nd amendment, the penalty may be imposed on the basis of evidences adduced such inquiry. Means that there is no legal requirement that the second hearing is to be given. Means that law has been now changed. Although he will be given opportunity, the first opportunity, as and when the charges are going to be framed, or charges are going to be charge sheet is going to be served. But the second opportunity, when the penalty is going to be imposed, that has been abolished by 42nd Constitutional Amendment. And now question arises, okay, what's the meaning, what's the definition? What's the meaning or what the definition of civil post? Because we always talk, that all these provisions are meant for civil servants. So civil post. So the stated above safeguards can be limited to the class of persons who hold civil post, because that the military, those who are having post in military, armed forces, or your naval forces or air force forces, those posts cannot be termed as civil posts. So it is not available to the defense of personal or even civil. It is not available to the defense personnel or even the civil employees employed by the defense services. So the armed forces are governed by the special acts. All of you know that it is the Army Act, it's the Navy Act, or it's the Air Force Act. A civil post means the appointment or office or employment on the civil side of administration, and there must be a relation of master and servant between the state and the person holding the post, in that the person employed in the police department holds the civil post, but employees of statutory corporations or government companies are not covered under the heading of civil post. In uh, one case, it was although very old case, but it relates to the post of temporary post and probationary posts, or on probation. Okay, what would be the fate in case if the person holds a temporary post? So, in one case, it was the case of Purushottam Lal Dhingra versus Union of India, and it was the case of 1958. Here, the Supreme Court hold that reasonable opportunity is the right of temporary servants, as uh, it is it is of a permanent servants. But later, in many situations, came before it which necessitated the formulation of general rules. For example, that if a government employ a person for a specific project, for a specific work or uh, project, then and terminates his services when the project comes to end, and no hearing is required because of the nature of employment. Means that it also depends upon the nature of the employment. What kind of nature of employment has been uh, you know hired, or the rules were formulated by the Supreme Court. In another case, it was the state of Punjab versus Shukraj Bahadur. It was the case of 1968. And in this case, the services of the temporary employee or of the probationer may be terminated in accordance with the rules of employment, or such termination does not call for an inquiry. Means that there we can say that sometimes there may not be application of Article 311. So the circumstances, because you know that it's the very important situation, that the circumstances preceding the termination have to be examined. The motive behind it is immaterial. Means that under what circumstances the services was terminated of the temporary employee or the probationer. In and if the order visits the public servants with evil consequences, or casts a stigma on his character or on his honesty or integrity, then the order is to be considered by the way of punishment. And in such cases, we can say that it is one kind of exception even with the probation and the with the temporary employee. That in case if it is to be considered or it is to be proved as a punishment, then in such cases, Article 311 is attracted, even in case of probationer or in case of you can say temporary servant. But if the order is in simple form, which does not cast any aspersions on the civil servant, means that the order is not going to attack on the reputation or integrity of the uh, public servant, then Article 311 is not attracted, even though superior authorities conducted an inquiry to ascertain the suitability of the public servant to conclude whether to retain him or not retain him. So, if there is an inquiry, a charge sheet is served, and inquiry officer is appointed, and explanation is called, Article 311 apply. Then Article 311 apply, means that reasonable opportunity, etc., are to be given to the delinquent employee, or we can say they are to be given to the person who is going to be sacked from his post. Now, uh, the term that a person who is dismissed and who is dismissed is not eligible for re-employment. I mean, what's the difference between dismissal, removal, and reduction in rank? means that a person who is dismissed, then he is not eligible for re-employment in future under the comment, and a person who is removed does not become disqualified. He could be retained. He could be retained and may be re-employed. But both are the termination of services. Under Article 311 treats both in the same manner. All termination of services may not be removal or dismissal. Both removal and dismissal are penalties awarded on the ground of misconduct or inefficiency. Both entail penal consequences which are contained in the several rules. In both the cases, Article 311 clause 2 is to be attracted. Means that Article 311 means that there has to be given a reasonable opportunity to being heard. Then reduction in rank means the degradation in rank of status of the officer directed by a way of penalty. The government servant is reduced to lower post or rank or to lower stigma in pay scale. In lower stage in pay scale. So this is done by the way of penalty. So the form of order is not conclusive. In case the court must look to the all surrounding circumstances and determine whether the order was given as a punishment or not. And in case if it is going to be given as a punishment, then there is the attraction of Article 311. Now, another issue, that is the issue of suspension, which relates to the government employee. The suspension of government servants is neither the dismissal nor the removal. Hence, an employee who has been suspended cannot claim the protection of Article 311. Generally, another provision has been made in the service conditions or service rules. It is the issue of compulsory retirement. Now, generally, the rules of employment for compulsory retirement of the government servants after he has rendered the prescribed years of services, means that sometimes what happened, extension in case of state government, the extension is to be given for 3 years, because in most of the states the superannuation age or retirement age is the 60 years. So at the age of 55, or I'm citing example that suppose at the age of 55, the premature retirement is done in public interest. In the case of other services also, means that the case of central governments also, nowadays you are also seeing the examples in Delhi government, that few dishonest officers and corrupt officers or corrupt delinquent employees, they were forced to have, or they were forcibly or compulsorily retired because of their conduct. So that's why it is to be exercised in the public interest, and it does not cast a stigma on him. So no punishment is involved. So if the decision is to retire has been taken in bona fide manner, then its correctness cannot be challenged in the court of law. And compulsory retirement does not attract the safeguard of Article 311 clause 2, because it is not regarded as a punishment. But you know that in case if it is to be found that the compulsory retirement has been made malafidely, has been made prejudicially or discriminatorily or arbitrarily, then they could move to the court and they could seek the judicial review of their compulsory retirement. Now, under Article 311, Clause 2, which talks about the reasonable opportunity, uh, you know that Article 311, Clause 2 gives to the government servants a valuable right. He is not to be dismissed or removed or reduced in rank except after an inquiry, in which first means what are the contents of reasonable opportunity. All these contents must be must satisfy for the sake of reasonable inquiry. First, the department, the delinquent servant should be informed of the charges against him, and the charges must be clear, precise, and accurate, and he should be informed of the evidence by which uh, mm, by which the charges are sought to be substantiated. So, if the government servant demands a personal hearing, it must be provided, and he must be given an opportunity to cross-examine to cross-examine the witnesses produced against him, and all evidence must be given in his presence. No material, no material may be relied on the against the employee unless he is given an opportunity to explain it. The employee should be given full opportunity to adduce evidence and to produce witnesses. The employee has a right to argue his case. The inquiry officer should not have a bias or prejudice in the matter. The inquiry officer himself cannot be a witness against the delinquent employee. The inquiry officer has a personal stake in the inquiry to be, and in case if he is having a personal stake in the inquiry, then he is disqualified from conducting the inquiry. So, above rules are derived. All of you know that all these rules reflects what what is being reflects from all these rules or all these contents. All these are going to be reflect the one important principle. It is the principle of natural justice, and you must have been gone through this important provision of principle of natural justice in your other courses of law, like other subjects of law, like your administrative law, and I think you know that you must have been taught in very detail, especially related to the principle of natural justice. However, we can say that the broad principles are under the principle of natural justice that no one can be a judge in his own cause. Second, both the parties must be heard. Third, reasonable notice must be given. And fourth, there should not be there should not be there should not be no bias. So when inquiry is not required, because sometimes you know that there are the situations, there are the conditions in which inquiry is not required, and when we can say that it is one kind of proviso to article 311 clause 2, and when uh, article 311 clause 2 is to be excluded, there has to be certain circumstances, there has to be certain we can say situation in which the principle of natural justice, or you could say the principle of reasonable inquiry, may be excluded if the circumstances demand, if the we can say situation demands. So here are uh, I'm going to discuss, uh, going to cite the examples or the case law which relates to this exception, that is we can say that is the proviso to article 311 clause 2, and which talks about the exclusion of natural justice. So in the further proviso we can say that we are having uh, three situations. It is a proviso to article 311 which talks about the subclause A, B, C. So first situation we can say where reasonable opportunity is not available in the following circumstances. First, conviction on a criminal charges, where a person is dismissed or removed or reduced in rank on the ground of misconduct which had led to conviction on a criminal charges, then then he can be denied for reasonable opportunity. As in the in one case, uh, in one case, it was the case of K. Vakanteswara, K. Vakanteswaralu versus state of Andhra Pradesh, and it was the case of 2011. It has been held that where the trial on a criminal charges results in conviction of a public servant, a disciplinary proceedings are bound to follow against him even in case of acquittal. Depart, Even in case of acquittal, departmental proceedings may follow when the acquittal is other than honorable. So, in this situation, that in case of conviction on the criminal charges, then the delinquent employee could be removed, could be dismissed, or could be reduced in his rank without without giving him in reasonable opportunity, uh, because of this exception or because of this proviso to Article 311 Clause 2. Next situation, not practicable to hold inquiry. Sometimes if the situation demands or circumstances demand that it is not practicable to hold the inquiry. So where the authority empowered to dismiss or remove a person or to reduce him in rank, if it is satisfied that for some reasons to be recorded by the authority in writing, it is not reasonable, reasonably practicable to hold such inquiry. So, for example, that in case if the in real sense if the reasons are going to support, then reasons are going to support that it is not practicable to hold the inquiry, then the principle of natural justice can be excluded. But in case if it is not going to support, reasons are not going to support, then the government could not deny or could not apply this proviso to Article 311 Clause 2. As in one case, it was the case of Jaswant Singh versus State of Punjab, and it was the case of 1991. And in this case, what happened? That it was the appellant who was dismissed from service without holding departmental inquiry by exercising the power under Clause 2 of second proviso to Article 311 Clause 2 of the Constitution. Two reasons were given in support of his subjective satisfaction of the authority. First, that the appellant had thrown threats that he would not allow holding any departmental inquiry against him. Second, he and his associates would not hesitate to cause physical injury to disclose the court uh, physical injury even to the witnesses to the court of the inquiry of the officer. So it was held that the respondents means that it is the state of Punjab. The respondents have failed to disclose the court the material in support of subjective satisfaction. The decision to dispense with the departmental inquiry cannot be rested solely on the uh, ipse dixit of the concerned authority. Means कि unknown, unproved or unproven, unproven uh, procedure or uh, unproven reasons. Proved reasons are to be there. Ipse dixit of concerned authority show that when the satisfaction is questioned in the court of law, it is the duty of the respondent to show that the satisfaction is based on certain objective facts and not the outcome of whims and caprice of the concerned officer. So, in the absence of any independent material to justify the dispensing with the inquiry envisaged under Article 311 Clause 2, the order of dismissed cannot be sustained or cannot be maintained. Accordingly, directed. The appellant was directed to be reinstated in service forthwith all monetary benefits as to pay, allowances, etc. So available to him from the date of its dismissal. So in this case, the although provision is there that in case if there is not practicable to hold the inquiry, then the employer could remove or dismiss or reduce in rank to the delinquent employee. But in case if it is not going to be proved on material facts, then you know that it will be unfair, it will be arbitrary, and it will be unjustified to exclude the principle of natural justice. Another very important proviso which talks about that where the president or the governor, as the case may be, is satisfied that in the interest of the security of state, it is not expedient to hold such inquiry. It is hold in such inquiry, then the proviso to Article 311, Clause 2 and Clause C is to be applied. And here we are having, one important case in this chapter, that is the Union of India versus Tulsiram Patel. And here, that series of cases or series of examples which has been decided under this proviso. And here the Supreme Court has held that the dismissal, removal, and reduction in rank of government servant under the second proviso of Article 311 without holding inquiry in public interests and therefore not violation of Article 311 Clause 2 and important Article 14 of the Constitution. The second proviso to Article 311 Clause 2 expressly provide that principle of audio alterum partem, rule of natural justice, shall not be applied in these circumstances mentioned in three stages or three clauses of the proviso. So this phrase leaves no scope for any kind of opportunity to be given to the government servant. The object underlying the second proviso is what's the object behind this proviso or this second proviso or that is the what's the object behind it that that is your public policy or public interest and public good means that in case if the proviso is to be exercised or power is to be exercised under the proviso to Article 311 Clause 2 that ought to be exercised in the interest of public policy, public interest and public good. When the principles of natural justice has been expressly excluded by the second proviso, it cannot be imported by the application of Article 14 of the Constitution. And as you know that in this instant case, means this Tulsiram Patel or this Union of India versus Tulsiram Patel. In this case, what happened that it was the petitioners means that that there are the certain cases which has been decided on the principles laid down in this Tulsiram Patel or in the light of proviso to Article 311 Clause 2. And in this case, petitioners had challenged the different rules, different services rules under which they were removed from services without holding any inquiry and without giving them reasonable opportunity of being heard. The first case, the respondent Tulsiram was convicted under Section 332 of IPC for causing head injury with an iron rod to his superior, and he was compulsorily retired under Clause A of second proviso to Article 311 Clause 2 and the service rules under Section 19 Clause 1. In the second case, the respondents who were the members of CISF, who were that they had created a righteous situation completely, breaking down discipline in the force, as a result of which the members themselves became a security risk, and there was a willful and deliberate disobedience of the orders of their superiors, authorities, and it was the situation, what kind of situation they had created, that army had to call. Army had to call because of the situation was out of control. So these acts virtually amounted to the situation of mutiny, and the respondents were dismissed from the service without holding inquiry. After without holding inquiry under Clause B of second proviso to Article 311 Clause 2 and Rules 37 Clause B of CISF rules. So the third case related to certain railway employees or certain railway servants who were either dismissed or removed from the service under Rule of 14 of the railway servants rules, read with the clause B of second proviso to Article 311 Clause 2 for participating in an illegal all India strike by the railway employees. In the fourth case, the petitioners belong to Madhya Pradesh Police, Police Force, and Special Armed Forces. The members of these two force indulged in violent demonstrations, creating security risk, and they were dismissed from the service by applying clause uh, C of second proviso to Article 311 clause 2. So that it was held that in all these above cases, the punishments imposed by the disciplinary authorities was proper and justified. On this point, although on this point the court overruled its earlier decisions. In this case, you know that the earlier decision, which was the earlier decision was it was the Chalappan's case. Chalappan's case, Divisional Personnel Officer, Southern Railway versus T.R. Chalappan, which was decided in 1976. Now the court overruled its earlier this decision, where it had held that the imposition of penalty of dismissal or removal or reduction in rank without holding an inquiry was unconstitutional and illegal. So the view taken in Chalappan case that an objective consideration is only possible when the delinquent employee is heard and given chance to satisfy the authority regarding final orders is not correct and cannot be accepted. That's why the earlier approach propounded by the Supreme Court, it was uh, it was overruled in this landmark decision, Union of India versus Tulsiram Patel, which was decided in 1986. Means that after 10 years, this earlier approach was overruled itself by the Supreme Court. However, in those cases where the proviso to Article 311 clause 2 is to be applied, it was held that the government servant is not wholly without any remedy under the services rules made under 309. Thus, where the second proviso is to be applied, uh, uh, 311 clause 2 applies, though there is no prior opportunity, means that the government could exercise its power for excluding the principle of natural justice, although there is no prior opportunity to the government servants to defend himself against the charges against the charges made against him. But still, he has having two remedies available to him. First, departmental appeal under relevant services rules to show that the charges against him were not correct, the charges against him were not true. Second, remedy of judicial review, means that he could move to the court, where the court will examine whether the penalty imposed on the aggrieved person is arbitrary or grossly excessive or was not warranted by the facts and circumstances of that case. So it's all regarding to the to this article or to this topic, services under the union and the states government, the service condition of the government apply under the union and the state government. So thank you. Again, that I would like to make a request that in case if you have any doubt, so perhaps that our two students are going to engage one meeting. What I came to know today only. So in case if that meeting is going to be arranged, then we'll meet on Zoom or on video conferencing, and I will try to clear all your doubts. And in case if I would fail to remove the doubts, then again in next meeting I'll take up all those doubts. Thank you, thank you, thank you.